questions, so turn to my good friend from Minnesota for any questions she may have for our panel.
Thank you, Mr. Chair, and I just have a real, well, maybe quick, but for Chairman Turner and Chairman Jordan, can you discuss how this is the appropriate balance between empowering law enforcement and respecting civil rights or liberties?
This is a really good opportunity for us, I think, to get an agreement from everybody who's here, right? Because one of the issues that we always have whenever we're discussing FISA is it gets so confusing of the fact that we're only talking about one foreign intelligence tool. I mean, there are all types of other issues that judiciary has to deal with and we have to deal with. But I think, first off, before we go forward, we should probably get an agreement between the four of us so that at least the Rules Committee has an understanding that we're all talking about the same thing. 702 is foreign surveillance of foreigners abroad. Can we have universal agreement between the four of us, because it is what the law states. It is, and I have it in front of me. It is surveillance of foreigners abroad. Ranking Member Nadler's agreement.
Mr. Chairman, is the witness supposed to direct his comments to us or to the other witnesses?
No, actually, you're correct. You should address your comments, please.
Well, we're a team, so I'm making certain that I consult with our team as we give the answer. For the record, everyone has agreed, Chairman Jordan, Ranking Member Nadler, my ranking member, myself, in my framing your answer, that we're talking about foreign surveillance of foreigners located abroad. What we found in this process of 702, because there's two really big provisions we're dealing with. We're dealing with 702 and we're dealing with the court itself. They are separate. Under 702, what we found is that the FBI had an unbelievable number of abuses where they were routinely looking at the data of foreigners located abroad, searching it for Americans' data, and whether or not Americans were located in that. What they found is their computer system was set up so it did it automatically. They didn't have any criteria for determining whether or not Tom Cole was searched as to whether or not he was communicating with ISIS in any of their processes. He is not. They changed those processes upon our raising these issues with them, where it's, as Jim said, it was like 280,000 times that in a year that they were violating that they reduced those down to 680. What you'd find is that when they were searching Hamas's data and ISIS data for unrelated Americans, 98% of the queries returned zero information because those individuals were not corresponding with the 250,000 people that we consider some of our most national security threats or issues. So what we've done in this, though, is that we've limited the number of people who can do it. So we've made the standards higher, the professionalism and training higher, and then we've put on it real consequences, real criminal prosecutions for intentional violations and for those who use this information inappropriately. On the court side, we really nailed it down. We made it certain that information and data was not admissible before court. If someone did so, that was used against the Trump administration, if someone did so, they had criminal prosecution. We made certain that if it's a U.S. person, that an independent attorney is appointed and is part of the process to be a counter to ensure that the laws are followed. And we also made certain that there is a hearing and a transcript, and that data is made available if there should be subsequent legal proceedings, so that the American citizen would have access to it and be able to challenge it.
I would just respond by saying we have no problem with surveilling foreigners. It's the Foreign Intelligence Surveillance Act, as the chairman just said. What we have a concern about is a term that Ranking Member Himes, I think, used 4 times in his presentation: U.S. person queries. And that's a fancy way of saying U.S. person searches. They are searching Americans. So that is our concern, and we know, not according to Jerry Nadler and Jim Jordan, but according to the Washington Post and information we've received, from the Inspector General and others, the FBI, this is quoting straight from Mr. Barrett's piece a year ago, the FBI has misused a powerful digital surveillance tool more than 278,000 times, including against crime victims, January 6 riot suspects, people arrested at protests in the wake of the police killing of George Floyd in 2020, and in one case, as the ranking member referenced, 19,000 donors to a congressional candidate, according to a newly unsealed court document. That has nothing to do with Hamas or Hezbollah. That's U.S. person searches, not queries, searches of their information. And the author goes on to say, the failure to use this 702 database correctly when collecting information about U.S. citizens and others make it harder for the agency to marshal support for Congress to renew the law. That's why we're saying information picked up in this, what is becoming a bigger and bigger haystack of information about American citizens, U.S. persons in there, if you're going to query that, you're going to use a phone number, an email, or a name, as the ranking member said, you should go get a warrant to do that. That is the crux of the matter. Of course we want bad guys overseas, of course we want to surveil them, but we're talking about the term that Mr. Himes, again, used several times in his opening statement, U.S. persons.
This is why this is so important that we had the agreement before I started answering your question.
Yes.
Because what Jim said is absolutely right. I mean, the abuses were horrific. I mean, the whole fact that people who were arrested during the George Floyd riots had their names searched in Hamas's data is an absolute violation. Now, under 702, the people who were arrested for protesting for George Floyd, under 702, they didn't go search their data. They went and searched Hamas's data and ISIS's data. The problem is that Jim and Ranking Member Nadler want to have a warrant to search Hamas's data and ISIS's data. There's already a warrant requirement to go and search an American's data, to go and search their data. But if you're going to go look in Hamas or ISIS, and you're an American citizen that's corresponded with ISIS or Hamas, there should not be a warrant to look at that data.
With all due respect, I think the chairman misunderstands the bill or the situation. Of course you don't need a warrant to surveil Hamas. No one claims you do. But when it comes to surveilling an American person, a U.S. person, like any other situation, you should need a warrant.
That is the law.
It is not the law.
It is absolutely the law.
Well, if it is the law,
I mean, right now, under the law, if you are going to surveil
which case-
an American citizen, you need a warrant. It's
which-
only if you're searching Hamas's data or ISIS data that you don't need a warrant, and that's what you want to put a
Well,
warrant on. And I think the American citizens believe that if somebody is corresponding with Hamas and ISIS, for example, if they send them an email that says, thanks for the bomb-making classes, we ought not have to get a warrant to look in Hamas's data that we have to find out that they thanked him for bomb-making classes.
Again, if you want to search Hamas, that's fine, and no one claims you need a warrant. If you want to search a U.S. person, you should need a warrant. Now, you say we do already.
Right.
But let me finish.
Okay,
You say we do. If we do, then the amendment that the Judiciary Committee proposes requiring such a warrant should not be objectionable to
No,
you.
that's not what your warrant says. So let's go over it, because, I mean, we have it, and I think certainly for the Rules Committee, people have to vote. I mean, if there's confusion among the four of us as to what your amendment does, then we need to clear it up. Your amendment says that there would be a warrant required to look in 702 data, which is foreigners located abroad's data, the 250,000 that we identify as the most national security threat, if there's an American's who has communicated with them.
No,
That's what your amendment says.
You misunderstand the amendment. What the amendment says is that if Hamas, whom we are properly surveilling, or any other people for that matter, the Chinese communists, whoever we're surveilling abroad, we find that they communicate with an American. Now, we have the metadata.
But under your amendment, you
Uh,
can find that.
excuse me.
Let Mr. Nadler, I'd like to hear what he's having to say.
I'm just going to remind our witnesses, please don't talk to one another, talk to the panel.
We
And
have-
please don't talk over one another,
Yeah.
it's very
We
difficult.
have
to
the
stop.
metadata. That is to say, the name and phone number, or presumably the phone number, of the American person that Hamas, or whoever abroad, called. If we want to know, however, if you want to surveil all the phone records of that American person, like any other search, you ought to need a warrant.
That's current law.
It is not current law. If it is current law, then the amendment that we have here saying that a probable cause warrant to conduct a U.S. person search of the 702 database with limited exceptions for exigency, cybersecurity, and victim consent should not be objectionable.
No, what you just said.
Excuse me,
Sorry.
Again,
actually.
I asked you not to interrupt one another, not to talk to one another, answer the gentlelady's question.
And I was going to ask Chairman Jordan, because I was curious if there was another answer in between. Okay,
I agree with Ranking Member Nadler. It's why we put the amendment, and understand, we have exceptions in the amendment. Ms. Fischbach,
Yep.
we say, if it's an emergency situation, and you think the time element, or whatever time element that is, even though that's constitutional, there's an emergency situation, or if there's a permission. The example that I think the ranking member of the Intelligence Committee gave, if two people in China are talking about a member of Congress, go talk to that member of Congress and say, hey, do you care if we query this database? Because we think these guys are trying to target you in some way. Of course, that individual, that member of Congress, go ahead, figure it out. We want to know what the Chinese are trying to do to a member of Congress. And then the third one is if it's a known cybersecurity threat, some known malware that's been used, that's an exception as well. So we tried to structure this warrant requirement with some exceptions, so frankly, we're giving on the side of the Judiciary Committee in the way we structured this, because we get this national security issue, but we also get the Constitution. And we also get this fundamental principle that it's a separate and equal, we have separate and equal branches of government to put a check. You don't want the executive branch being able to just not follow the rules, or the rules that are in place, they get to do their own thing. That's why we have a separate and equal branch that has to okay it when you're going to go get information about an American citizen.
I will just say thank you very much, and I'll yield back, Mr. Chair.
Thank you.
Thank the gentlelady. I now turn to my good friend, the distinguished ranking member, for any questions he has.
Yeah,
about.
just